recording is starting now. So Dina, you can kick it off.
Hi, good afternoon, everyone. My name is Dina Bakst, and I'm co-president of A Better Balance. Thank you all so much for joining us today for our webinar, Women's Equality Advances in New York. As you all know, this session, the New York State Legislature advanced a number of measures to advance women's health and economic security. Many of these measures were part of Governor Cuomo's Women's Equality Agenda, which is a 10-point plan announced at the 2013 State of the State address to break down key legal barriers that cause gender inequality in the workplace and society at large. This agenda was supported and advanced by the New York for Women's Equality Coalition, a diverse group of organizations led by a steering committee, and you can see the groups listed here, that rapidly grew to 850 groups and organizations in a matter of months. So what did the agenda include? Here's a quick recap. As you can see, there were 10 points. The first one, secure equal pay for women in the workplace in New York, outlaw sexual harassment in all workplaces, provide for attorney's fees for prevailing litigants in sex discrimination cases, end family status discrimination, move to end housing discrimination for domestic violence victims and those who receive public assistance, expand access to orders of protection via new technologies, strengthen protections for survivors of human trafficking, require employers to make reasonable accommodations for pregnant women in the workplace, and practices of arresting DV victims who need to be in contact with their abusers, and enact reproductive health protections. So why were these protections and so necessary? To begin with, as you can see here, we just bulleted a couple of powerful statistics that underscore the need to address these legal loopholes. As you can see, some women in New York earn 85% of what men earn, and that disparity is even far more drastic for African American women and Hispanic women. Inequality persists throughout the course of a woman's lifetime, meaning a woman is twice as likely as a man to live out old age in poverty. And women who are pregnant or have children are less likely to be hired, promoted, or given raises. And women are 5 times more likely than men to be sexually harassed, and 1 in 4 women will experience intimate partner violence in her lifetime. So we'll spend the next 40 minutes or so going over each of the provisions of the Women's Equality Agenda and what they'll do for the women of New York State, along with a discussion of the reproductive health provision that was left undone. We'll also cover several other excellent pieces of women's rights legislation that passed this session that also strengthen legal protections for women. One is a bill supporting breastfeeding mothers, another bill combating campus sexual assault, and a third bill strengthening legal protections for nail salon workers. We'll then spend a minute on paid family leave, a priority for A Better Balance and NYCLU, and many of you in this upcoming legislative session. We'll then leave time for Q&A, so please be sure to type in any questions that you have in the sidebar. So let me kick it off, and then I will turn it over to my colleague, Corinne Carey of NYCLU, with the very first point of the Women's Equality Agenda, which is equal pay. Why is equal pay so important? Well, pursuant to longstanding federal and state law, employers are not legally allowed to pay a worker less because of her sex. Unfortunately, some employers still do, jeopardizing the economic security of women and the families they support. The 86% gap between male and female workers in New York State means the average woman working full-time makes $82,250 less per year than her male counterpart. These women and their families are denied the equal pay that amounts to over a year of groceries, 8 months of rent, or 3 years of family health insurance. And many women of color are hardest hit. African American women only earn 64%, and Latinas only 56% of the amount earned by white men. This injustice exists in part because of inadequacies with New York's equal pay law, which has been thankfully fixed in this session. So what does this new law do? So to begin, this new law tightens exemptions in the previous version of the New York labor law, which allowed employers to cite nearly any other factor than sex, legitimate or otherwise, to justify pay differentials. So specifically, it closes the door on this huge exemption by ensuring employers have to justify a pay differential with a bona fide factor other than sex. So what does this mean? It means that if your employer pays you differently than someone of the opposite sex, then the differential has to be job-related and consistent with business necessity, but not based on a sex-based wage differential. So, for example, if you find out that your male coworker with similar responsibilities is getting a bigger paycheck than you, it could be illegal discrimination. This could take many forms: missing out on a bonus or pay increase that male employees receive, being passed over for promotion, an accompanying raise for which you are qualified, in favor of a male who is less qualified or receiving fewer benefits than your male coworkers. Unfortunately, it's often difficult to find out whether you are in fact being paid less because many workers are unaware of what their coworkers make. Employer wage secrecy policies punish employees who share their wages. In fact, 61% of private sector workers in the U.S. report they're discouraged or outright prohibited from discussing wage and salary information. So the second key thing this pay law does is it targets the problem by creating legal protections for workers who share wage information with their coworkers. Specifically, the law states an employer cannot prohibit you from inquiring about, discussing, or disclosing your wages or the wages of a coworker at work. This important new protection helps ensure workers actually know when their right to equal pay has been violated. And finally, this law strengthens equal pay protections by increasing the amount of damages available when an employer willfully violates the law. So if you can prove your employer paid you differently in a willful violation of the law, then you can get up to 3 times the amount of money from your employer that you lost from being underpaid. And nearly all employers in New York are covered by this law, with the exception of those who work for a government agency. So we'll now turn to prong 2, sexual harassment. So the next bill that passed the New York legislature seeks to end sexual harassment on the job for every employee in New York State. So what is sexual harassment? Sexual harassment is defined to be a verbal or physical conduct of a sexual nature that unreasonably interferes with your work performance, affects your employment, or makes your workplace intimidating, hostile, or offensive. This means it's illegal for someone at work, including a coworker or a customer, to make unwanted sexual advances towards you, make you feel uncomfortable through sexual words or actions, request sexual favors from you, engage in sexual conduct that is used as a basis for hiring or other employment decisions. This is actually often called quid pro quo harassment. For example, if someone said, I'll give you a promotion, but only if you sleep with me, then this would be illegal. Too many women in New York State and nationwide find themselves forced to choose between quitting and trying to endure these sexual advances or aggressive behavior. And this psychological and physical and economic consequences for women in these situations are often devastating. Formerly, New York law only protected you from sexual harassment if your workplace had 4 or more employees. Now, it doesn't matter how big or small your employer is. All workers are legally protected from sexual harassment and are eligible to file sexual harassment complaints with the State Division of Human Rights. And I just want to note this fix is critically important because experts have found that employees in smaller businesses actually may be more susceptible to sexual harassment due to many factors, such as a lower likelihood of established policies or practices around sexual harassment, a less formal workplace culture, less awareness among superiors and colleagues of workers' rights and what sort of actions constitute sexual harassment, and greater tendencies among those in charge to believe that workplace sexual harassment is not a serious problem. So I'm now going to turn it over to Corinne Carey from NYCLU to talk about attorney's fees.
Great. Can you hear me?
Yes.
Terrific. So the third piece of the agenda that passed is a bill that would allow for attorney's fees in employment credit and housing sex discrimination cases. Prior to the enactment of this law, New York State is one of 9 states in the company of Mississippi and Alabama that doesn't already allow successful discrimination defendants to recover attorney's fees. successful discrimination plaintiffs to recover attorney's fees. Approximately 77% of all employment cases based on sex, and the majority of credit and lending discrimination cases are filed by women. And if a victim of discrimination can't afford to hire an attorney, she can't seek redress. Those who do hire an attorney on a contingency fee arrangement are never really made whole for their losses because they have to pay the attorney's fees out of their recovery. Adding to the burden of this problem is the fact that many low-wage workers can't even hire a lawyer on contingency fees because the recovery amount that they will get at the end of the process is so low that lawyers are reluctant to take cases that are either will result in too small of a settlement or are too risky on contingency. So it's difficult for a woman to find an attorney even if she's willing to pay out of the recovery. So what the legislation does is it will allow litigants who win a sex discrimination suit to collect attorney's fees. The bill amends state law to include a provision for reasonable attorney's fees for successful litigants in employment, credit, and housing discrimination cases. For employment and credit cases, that is when the discrimination is based on sex. New York City has a comprehensive anti-discrimination statute, as does Buffalo, Syracuse, and Ithaca. This law will ensure that the attorney's fees are available to plaintiffs statewide when they are prevailing in a sex discrimination case. So that's the attorney's fees provision, and I'm going to hand it over to the family status discrimination piece.
Hi, everyone. This is Phoebe from A Better Balance, and I'm going to be speaking about family status discrimination. This is an area of discrimination that we felt at A Better Balance was important to make explicit under the law because of something known as the maternal penalty or maternal bias in the workplace, but it also affects fathers. And the idea is that there's, prior to this law, no explicit protection against discrimination in the workplace on the basis of a worker's status as a parent or in a legal relationship and give them a parent relationship. And although prior to this law, both under state and federal law, there were ways to capture those situations as sex discrimination, too many people were falling through the cracks because they simply didn't have enough evidence to show that what they were experiencing was sex-based as opposed to based on the fact that they were a parent. One example, somebody who came to our hotline and clinic a few years ago, she had worked for the same organization for 15 years in one particular role where she was able to work pretty regular hours in order to be able to return home and take care of her then 11-year-old daughter. And then her job got switched up on her to a new position where suddenly she had to do unpredictable night and weekend hours that made it really difficult for her to actually, secure care for her daughter. And ultimately, she had asked for some way to work around this problem, and her employer was really reluctant to engage with her, although at the same time allowing another employee who did not have kids and was going to school outside of work to change their schedule. But at the end of the day, she was fired, and it was because of her childcare issues, because she, was a parent. And so that's sort of what we're trying to get at and what this law is addressing. As the slide shows, mothers earn 5% less per child than non-mothers, even when we control for other factors like education and work experience. And there have been studies to show they're less likely to be recommended for hire and promotion. So there's a real, often unconscious, sometimes spoken, sometimes not bias against parents, and this is going to be helpful, as I said, not just for mothers, but for fathers, as well as workers who are pregnant or in the process of securing legal custody of a child. So as the bullets indicate, this makes it illegal for an employer to discriminate. Boss can't fire you because you're adopting a child, and your boss thinks you won't be as dedicated to your work as a result. And an alternative example, a company can't refuse to hire you just because you're a single mother. This law is an amendment to the New York State Human Rights Law, which covers all employers with 4 or more employees. So anybody who's working for such an employer or is applying to work for that size employer would be covered by this law. Okay, I think I'm going to turn it over back to Corinne for domestic violence.
Sure. There were actually two bills passed to address survivors of domestic violence, and they entail three different pieces. So I'm going to talk about those two bills now. Well, both men and women experience domestic violence. Women are disproportionately affected by intimate partner violence, with more than 1 in 3 women experiencing rape, physical violence, and or stalking by an intimate partner in her lifetime. And many of these victims and survivors of intimate partner violence face unique challenges in seeking stability and safety after escaping abuse, including homelessness and inadequate access to shelter and housing resources. The challenge of finding safe and affordable housing is exacerbated by the fact that many survivors are discriminated against, such as when landlords refuse to rent to a potential tenant who is identified as a victim of domestic violence. In addition, nationally, the statistics show that 11% of evictions involve. I'm sorry, 11% of evictions in. I'm stumbling over these words. Evictions involve violence. Let me start again. 11% of evictions involve victims of domestic violence who are evicted due to abuse. And female-headed households account for 76% of all people who receive assistance in housing. So what this legislation does is that it combats a bunch of those problems with the following provisions. It prohibits building owners, managers, and leasing agents from refusing to lease a unit or evicting a tenant because of her status as a domestic violence victim. In addition to civil remedies for refusing to rent based on an applicant's domestic violence status, it provides an affirmative defense in housing court that so that the reason for the eviction has to be based on something other than the survivor's status as a domestic violence victim. The bill also contains a provision allowing building owners and agents to request information about an individual's status as a DV victim for the purpose of providing assistance. So there was a fear early on that if there was a prohibition against asking someone's status as a domestic violence victim, which would enable them to discriminate against a survivor, this would allow housing providers that cater to survivors to actually request that information. It's an exemption in the bill, so as not to jeopardize that kind of housing assistance. The bill also creates a task force to study the impact of discrimination against those who receive housing assistance. Anecdotally, housing providers across the state know that when someone is seeking to rent an apartment with a Section 8 voucher or with public assistance, many landlords would turn that person away or even explicitly advertise that they don't accept Section 8 certification prior to rental. And so what this bill does is it establishes a task force to study the impact of this kind of discrimination with a particular focus on sex-based impact. The task force is required to submit a report to the governor and legislative leaders after the study year to make recommendations about whether to outlaw discrimination against Section 8 recipients and other public housing assistance recipients in the future. So those are the two provisions related to housing discrimination. The other bill that passed would authorize a pilot program for remote access to orders of protection. Now, in order for a victim to obtain a court order protecting him or her from the abuser, also known as an order of protection, that person has been required to testify in front of their abuser in court. A large percentage of survivors of domestic violence reported that the process of obtaining and the act of receiving a civil order of protection to end the violence was burdensome and caused them stress and fear to appear in front of the abuser. And so what this legislation does is it authorizes the New York courts to establish a program to allow a victim of domestic violence seeking a temporary order of protection to provide testimony via video conference. Testimony via video conference would be optional so that victims can retain the choice in determining how best to pursue justice. This pilot program existed in Orange County. There was a small demonstration project, but now the courts will be authorized to allow for video testimony elsewhere in the state. So those are the two domestic violence bills that passed, and I'm going to move on to the bill that addresses human trafficking. Human trafficking is often committed behind closed doors. Statistics are hard to come by, but whether the person is trafficked into forced labor or prostitution, women and girls, who constitute the vast majority of victims, are profoundly harmed. Since New York first recognized human trafficking as a crime in 2007, few perpetrators have been held accountable, and far too many victims have been denied protection or have been re-victimized by our justice system due to gaps and loopholes in the current laws. For example, gaps in the law include disparity between the sentences received for those convicted of raping a young person and those convicted of patronizing a young person who's been trafficked. So the legislation does a number of things. It offers better protection to survivors of human trafficking, especially minors, by treating survivors as victims and increasing penalties to published offenders. Specifically, the legislation does four things. It creates an affirmative defense to a prostitution charge that the individual was a trafficking victim. It increases penalties for human trafficking and labor trafficking across the board. It creates new offenses in increasing degrees of the aggravated patronizing of a minor, and it creates a civil action for victims of trafficking so that they can go after their perpetrators for compensation once that person has been convicted. So that is what the bill does on human trafficking, and I'm going to send it back over to, I think, Dina to talk about the bill related to pregnancy discrimination.
Thanks, Corinne, and don't worry, everyone. We will be sharing these slides afterwards, so I know it's a lot of information. So on pregnancy discrimination, this bill is a bill to address a growing problem in New York State and around the country, which is that, pregnant women, especially those in physically demanding jobs, are too often forced onto unpaid leave or, even worse, outright fired from their jobs when they request a modest temporary accommodation to stay healthy. 3/4 of women will become pregnant and employed in their lives, and families relying on their incomes. 2/3 of families have mothers are as breadwinners. So when they lose out on critical women income and benefits when they need it most, entire families suffer. Pregnant women are not only set back with lost wages, they lose out on advancement opportunities, or if they're pushed out altogether, new mothers have an extraordinarily difficult time re-entering the workforce, which ultimately exacerbates the gender wage gap. So, for example, Betsaida Cruz, a retail worker near Rochester, was fired because her doctor advised her to avoid heavy lifting. Even though she never had to lift anything heavy in her position as a cashier, her employer fired her without considering whether she could perform her duties if they could provide an accommodation that would allow her to continue. Due to losing her job, Ms. Cruz could no longer afford her rent, and she became homeless while expecting her first child. Unfortunately, her story is not an isolated one. A Better Balance has heard about many other women in similar situations, such as a pregnant retail worker who was rushed to the ER after fainting when her boss would not let her drink water, and a pregnant cashier who was forced to spend her 8 to 10 hour shifts on her feet when her boss refused to provide her a stool. We say that no woman should be forced to choose between critical income and maintaining a healthy pregnancy. And thankfully, there's been tremendous momentum on this issue nationwide. And now New York State has joined the ranks in ensuring that employers must provide reasonable accommodations to pregnant workers with medical needs, just as they are already required to do for disabled workers under federal and state law, absent undue hardship. In other words, they really need to engage in a good faith interactive process to figure out if they can find a way to keep a woman safe and employed during, the months of her pregnancy, and also to recover from childbirth. This law, is critical because women don't have the luxury of time in these situations. They often also, particularly women in lower wage jobs, lack the bargaining power. They don't have clear policies on paper. They don't have resources to hire a lawyer. They need immediate relief. They need the law on their side. It's also a public health necessity because women should be able to honor their doctor's notes, and when they do, they're less likely to have complications. And when they are accommodated during pregnancy, they can use their accumulated time that they use up when they're forced out on the back end to bond and care for a new baby. So briefly, what is a reasonable accommodation? There's a body of case law in New York that talks about what a reasonable accommodation is. It's a fact-specific inquiry, but common accommodations for pregnant workers include light duty, including help with lifting or temporary transfer, breaks to drink water or rest, changes to work schedule. So if you're having morning sickness, your employer may allow you to come in an hour late and work a bit later. And again, under the human rights law, you're covered under this law if you work for an employer with 4 or more employees. And I just want to note this law goes into effect 90 days after signing, and you'll see on the bottom of each of our slides when the law goes into effect. So please note those effective dates. Now I'm going to shoot it back to Corinne to talk about reproductive health.
Great, Dina. And before I do, I just, for those of you who are following against the list of 10 that we gave you at the beginning of this presentation, you'll see that we're skipping over the piece on orders of protection. Just to close the loop on that one, that bill was passed in 2013 and signed by the governor in November of that year, so it is already in effect. But I will just take a moment and say that it was a law that would have basically fixed a problem that if a person has an order of protection but has to communicate with their abuser, the subject of that order of protection, they themselves were subject to arrest. So, for example, if a woman invited her or there was a custody exchange where the woman came in contact with her abuser, she could be found in violation of her own protection order. So that issue was fixed in 2013, and that bill was signed, even though it was part of the original women's equality agenda. But turning to the last piece, the last formal piece of the agenda, safeguarding reproductive health, you all will know by now that of the measures in the Women's Equality Agenda, the Senate refused to take up this final piece. The Assembly actually passed this bill, but the Senate refused to bring it to the floor for a vote. So it is the one remaining piece of the Women's Equality Agenda that has not yet been done, and that will be a focus of our work in the year and the years to come. Hopefully not many years, but in the near future. New York's abortion law was enacted in 1970, 3 years prior to Roe versus Wade, and it lacks important protections found in federal law. Under New York law, the letter of the law, a woman's health is not protected in the rare and tragic situation that a serious complication jeopardizes her health later in pregnancy. New York law provides that a woman can only obtain an abortion after 24 weeks of pregnancy if her life is in danger, not if her health is in danger. So the women's equality legislation does some very simple things, and it was literally a 5-sentence provision within the agenda, and here are the 5 things that it does. It would codify in New York state law the 1973 Supreme Court decision in Roe versus Wade to, and this is the second piece, to ensure that a woman in New York can get an abortion within 24 weeks of pregnancy or when it's necessary to protect her life or her health. It would ensure that sections of New York's penal code that are contradictory to this new law are not enforceable. In particular, the provision of the penal code that prohibits abortion after 24 weeks when a woman's health is at risk. Many people didn't know this when we started doing this advocacy, but abortion is contained in New York's criminal code, not its public health code. And so this provision of the bill would basically say that those penal code provisions are not enforceable if a provider were to perform an abortion after 24 weeks when a woman's health is at risk. The bill also contained a religious refusal clause that ensured that if a healthcare provider, it was against a healthcare provider's religious beliefs, that he or she could not be forced against those beliefs to provide abortion care. It contained a sentence ensuring that the new law would not override the federal partial birth abortion ban of 2003, and it would ensure that physicians acting within the scope of their practice can't be criminally prosecuted if they provide abortion care in accordance with the law. However, it preserved those penal code provisions in current New York law so that the state would retain the ability to prosecute those who harm pregnant women. So that is what the reproductive health plank of the Women's Equality Act would do, and that's what we're going to be fighting for this remaining piece. There was some good news, though, on the reproductive health front this year because it was so very clear that the Senate refused to act. Advocates turned our attention to a number of other important reproductive health provisions, and we were met with some surprising and hopeful success this year. A bill expanding access to health insurance for pregnant women passed both chambers and will be sent to the governor for his signature this year. The bill would basically add becoming pregnant to the list of qualifying events that someone can enroll in health insurance outside of the open enrollment period. So anyone on this call who has health insurance knows that you can only enroll or change your benefits during an open enrollment period. And there are some exceptions to that. There are special enrollment periods for folks who get married, are released from prison, recently enter the country and become citizens, and also those who have a child. But there was no special enrollment period for women who become pregnant. So this bill would add becoming pregnant to the list of qualifying events for special enrollment periods. This is an important provision, and we're looking forward to the governor signing it, and all the support we can get in ensuring that he does will be helpful. The other two bills that got some traction but didn't get across the finish line this year, one is the Bakst bill. This is a bill that would prohibit employers from discriminating against an employee for his or her reproductive health choices. For example, taking adverse employment action or failing to promote someone because the employer does not believe in using IVF treatments, for example. This bill passed the Assembly, and there was bipartisan support in the Senate, but it stalled in the Senate Labor Committee. So advocates will be back at it again next year trying to get that bill, which was really fashioned as a response to the Supreme Court's decision in Hobby Lobby. We'll be pressing for that bill to be brought to the Senate floor next year. The third bill is the Comprehensive Contraceptive Coverage Act, CCCA, and it was originally introduced as a program bill by the Attorney General and then picked up by individual sponsors in the Assembly and the Senate. And it basically would have required insurance companies in New York to cover a wide range of contraception that a provider and a woman agreed was best for her body and her life. And advocates found that the measure had significant bipartisan support, but it was introduced so late in the session that it didn't make it through committees in the Assembly and the Senate. We are really hopeful that this bill will gain traction again next year and we'll be able to get it through. So those are the three alternative reproductive health provisions that we worked on this year, and I'm going to turn it back over to Dina to talk about breastfeeding.
I think, Phoebe, you want to go ahead?
Yes. This is Phoebe again. So as Corinne mentioned, we're moving out of the original 10 points of the Women's Equality Agenda into some other provisions of law that did get passed this session but were not part of the original 10 points. So the first of those is breastfeeding protections. And this is an issue for women who are coming back to work from giving birth to a baby, and because of the lack of paid family leave, which we'll talk about a little bit later, that often happens really quite early after a baby is born. And although there's plenty of public education and promotion of breastfeeding as a health benefit to both mothers and babies, there's still a problem in that we have to make it easier for women to continue nursing and continue breastfeeding even though they're returning to work. So as you can see in the slide, 80% of New York mothers have breastfed their babies at some point, but only 37% are breastfeeding exclusively at 3 months postpartum, and the number drops off even more at 6 months. So there's a real drop-off, and one study found that a mother returning to work is more than twice as likely to stop nursing as a mother who is not restarting work that month, and it makes sense. I mean, it's very hard to try to integrate nursing into a workplace if you don't have support. So this bill that passed this session was an attempt to help mothers understand the rights that already exist under New York state law and have been in effect since 2007, but have been not well known. And the goal is to try to reach women with this information when they're in a medical setting, when they're either pregnant or just recently gave birth, and before they're actually going back to work, so they have time to plan and think about their choices and strategize how they're going to continue nursing while returning to work. So the new law requires healthcare providers to include information about workplace rights for nursing moms that are already in the New York State labor law and have been, but to put that information in a packet called the Breastfeeding Mother's Bill of Rights, which is a broad-based informational packet given to all new mothers in health facilities throughout New York State. So the information provided there now to new mothers and to pregnant women include details about their rights under the labor law. So 3 points on that just highlight, because as I said, not enough women know about this, is one, time. Women are entitled to time to express milk for their baby, and they have this right to do so for up to 3 years after their baby is born. They can use paid breaks to pump or express breast milk, or if they don't get paid breaks, they can take unpaid break time of up to 20 minutes or 30 minutes if they have to sort of add extra travel time to a space where they can safely express milk. And they can do that break every 3 hours or as needed. Obviously, you know, a brand new infant's going to eat a lot more often and then require a mother to express milk more often than a baby who's 6 to 12 months old and eating less frequently and integrating solids. So the bill is designed to sort of, address a woman's own needs for her to feed her baby and to give her the time she needs to do that while at work. The law also says the employer has to give the employee a clean and private space other than a bathroom where she can pump without interruption, unless doing so would cause the employer significant difficulty or expense. So it's sort of a reasonableness standard here. The employer has to make every reasonable effort to provide a space, and it can be sort of it doesn't have to be a separate room necessarily. There are all sorts of creative ways to create this space, but it can't be a bathroom, which I think a lot of people don't understand, because a bathroom is not a sanitary place to eat and therefore not a sanitary place to produce food for an infant. And then finally, the employer has to give written information to women about their rights and cannot discriminate against a woman in any way or allow a work environment that's hostile to her rights if she chooses to express breast milk at work. It also, requires women in the Department of Labor's regulations. Women are supposed to, present a plan or to indicate before they come back to work that they want to pump and express milk. So there's time for the woman and the employer to work out the details. But as Dina mentioned in other contexts, it's really important for women, especially those in workplaces where they don't have a lot of bargaining power, to know that the law is on their side. And, there are plenty of women who just either don't start breastfeeding at all or stop really before they want to because they feel like they have to. They can't continue doing it when they're at work. And this law is designed to tell them that they don't have to make that choice. And then I'm going to go on to the next of the last 3 points here that were not in the original Women's Equality Agenda: nail salon workers. This is something that really just came up at the end of session. There was a coverage in the New York Times, which many of you may have seen, that was highlighting the dangers and abuses facing nail salon workers in New York State. There are estimated 3,000 nail salons in New York State and tens of thousands of nail salon workers, most of whom are Latina and Asian immigrant women. And they're exposed to dangerous health hazards on the job and often earn as little as $35 a day, with cases of wage theft being all too common. So there was an effort in the legislature and in the governor's office to issue new regulations and laws to empower agencies to do that in response to these concerns. So the new laws and regulations require employers to provide safety equipment and proper ventilation, including protective gloves and eye protection to ensure safety of workers, and also create a registration system for nail salon workers who have not been licensed, so that trainees are able to work their way towards license and are eligible for the same protections as other workers. So that includes, being paid minimum wage and granted meal breaks, and that, their tips and wages can't be taken from them. These seem like pretty basic things, but this is a workforce that has been largely sort of unregulated, unseen, and rampant violations of labor law. So there's an attempt here by the state to try to rein that in. And as the last point said, the regulations require employers to have funds available to pay employees who do bring lawsuits against them under the law. So I will turn it over on this last point to Corinne to talk about campus sexual assault.
So this is an issue that has also been in the news quite a bit over the past year or so. Sexual violence on college and university campuses is a serious and complex problem, and too often it's been addressed with dysfunctional campus disciplinary processes that fail to offer just outcomes for both the accuser and the accused. Following a number of high-profile cases, some of which were from New York, Governor Cuomo and lawmakers in New York met with survivors and their advocates. They held roundtable discussions to hear concerns from a wide variety of stakeholders, and they worked hard to craft strong legislation to address the problem. The extensive discussions that they had around the bill resulted in a set of measures that combat this problem. The bill contains a number of important pieces, and I'll just mention a few of them. A few of them are listed on your slide here, but I'll tell you a few more. The bill requires rigorous onboarding education for incoming students aimed at preventing sexual violence. One of the highlights of the bill, the one that's gotten the most attention, is a clear requirement that students engaging in sexual activity obtain affirmative consent for such activities from their partners. This isn't the sort of written consent that's been lampooned on right-wing talk radio and Fox TV, but this is sort of an affirmation at each stage of the sexual relationship that there is, in fact, consent. A strong set of rights and resources for students who experience domestic violence, dating violence, stalking, and sexual assault. The bill also imposes requirements on colleges and universities to assure a fair and impartial process to adjudicate allegations of misconduct. It offers strong confidentiality and privacy protections to those who report incidents of sexual violence. It offers amnesty from discipline related to campus rule violations for students who witness and report incidents of sexual misconduct. It requires colleges and universities to undertake a biannual campus climate assessment to determine how well students understand campus policies on sexual violence. And finally, it provides funding for community-based rape crisis programs to support those universities in doing what they do. You may have seen that the governor signed this particular bill yesterday in New York City. So this bill is now law. And I am going to turn it back to, I think Dina, to talk about the final piece that will, I think, become a big focus for many of us following the work that we've done this year.
Thanks, Corinne. So as you can see, there's been tremendous legislative developments this session. The Women's Equality Agenda provisions and the many other provisions that have been enacted to advance women's equality and economic security. Clearly, we are not done. We will be fighting for many sessions to come for women's economic security. One issue that many of us have worked together on and will continue to pursue in the legislative session, this upcoming legislative session, is paid family leave. Again, this is just one of many women's economic and family economic security measures that our groups are fighting for, but in the interest of time, I just wanted to flag it since paid family leave is also a central women's equality measure, because when women are afforded, data shows that when women are able to take paid family leave, they're able to return to the workforce quickly, stay attached to the workforce, and earn the fair and equal pay that they deserve. So this really cuts to the core of women's equality and economic security. Paid family leave, what also is stunning about paid family leave is that the U.S. is really stands alone among industrialized countries in failing to guarantee workers paid leave. When a loved one has a serious health crisis or when a new child is born or adopted, far too many American workers are forced to take unpaid leave or leave the workforce altogether. And low-wage workers and their families are especially vulnerable as they often lack the financial resources necessary. They are far less likely to be covered by corporate policy to provide paid leave. I know we've heard a lot about a lot of companies that are beginning to provide paid family leave, which is wonderful, except there are huge parts of our workforce that are not covered by employer policies and need a safety net at these critical moments in their lives. here in New York, there's national momentum on paid leave, but here in New York, legislation has been introduced in both the Senate and the Assembly to provide workers with 12 weeks of paid leave. In the Assembly, financed through small employee payroll contributions to care for a new child or seriously ill family member. Paid leave may be used to address certain needs related to a family member's military service or deployment. Prior paid family leave bills have passed the New York State Assembly for years and years. A better balance and a diverse coalition of community organizations, NYCLU, of course, unions, business, early childhood advocates, women, seniors, LGBT groups are really all united and committed to making New York State the fourth state country with a paid family leave insurance program. So we urge you to stay involved and as we continue to work together to make paid family leave a reality. And so with that, I think we are surprisingly very close to our scheduled time allotments. So now we are going to leave some time for Q&A from folks. I am now going to turn it back to Phoebe to read some questions that have come through.
Thanks. Yeah, I think Corinne was going to take the first two that came in. So the first question was, when is Governor Cuomo expected to sign these bills?
Great. Thanks, Phoebe, and thanks for the question. It's a good question. The governor has until the end of this session, which is officially the end of the year. So he has until December 31st at midnight to sign bills that passed during the session. Over 700 bills passed this session alone, and 650 of them still await delivery. So the governor signs a bill after it's been sent to him by the lawmaker who sponsored the bill. This is a package of bills, and we expect that they will be sent as a package to him. And we are, as a coalition, we're working with his administration on coordinating our efforts. And so we'll keep everyone apprised of when these bills come through. It could be sometime this summer or it could be in the fall. We're not worried about whether he will sign them. I think that we're pretty confident that all of them are pretty safe to be signed, but it's really unclear about when they will be signed.
Great, and thanks, Corinne. The next question, which I think you also said you'd be happy to take, is what does the attorney's fee bill say about an employer's entitlement to fees if it prevails?
Good question. You may have noticed, and apparently someone did, when I was talking about this particular bill, that it allows litigants who win a sex discrimination suit to collect attorney's fees, and that's very deliberate. So in order to be fair to both parties of the litigation, the bill amends state law to allow any successful litigant, and that could be the defendant or the plaintiff. So an employer can get attorney's fees under this provision, but the burden is a little bit higher. So the burden on an employer who seeks to recover attorney's fees is higher in that it requires the employer to show the court that the suit was brought by the employee, was frivolous. So they can't get attorney's fees in every case, only those cases where the court determines that the original claim was frivolous. I hope that's a good answer to your question.
Great, thank you. Yeah, if others have questions or follow-up on either of those questions, feel free to type them into the chat function on your screen, which is in the bottom left-hand corner, or at least on the left-hand side. A question for Dina about the pregnancy discrimination bill is, how is this different from or building on the Young versus UPS decision that the Supreme Court decided this year?
Mm-hmm. Sure. So the Young versus UPS is a really a standard of proof to prove intentional discrimination. While it was a victory for Peggy Young, it ultimately doesn't offer the clarity in the law that we believe pregnant workers need in order to stay healthy and on the job. It still requires a comparative analysis. So a pregnant worker needs to, the burden is really on the pregnant worker to look at her workplace and to figure out how others have been treated and whether a large percentage of workers, for example, are being accommodated and she is not being accommodated. And from a very, very practical perspective, we at A Better Balance run a free legal clinic, and when a pregnant worker calls to find out whether they are allowed to, take an extra bathroom break or carry a water bottle, that person does not have the luxury of time nor the resources to go on an investigation to determine whether they are entitled to a simple accommodation. It just doesn't work in a very, very practical way. And as I said before, these laws, the Americans with Disabilities Act, and it has amended, and accompanying state laws make it clear that workers with disabilities, including pregnancy-related disabilities, are entitled to accommodations in the workplace absent undue hardship. So this law is simply clarifying and extending a very well understood and usable framework to workers that may not necessarily have a qualifying disability, but still have a pregnancy-related medical need for an accommodation. So these laws are critically important, even in light of Young, and the states are really leading the way here.
Great, thanks. And I guess I'll throw this one out to either one of you. There's a question about paid family leave, and what are the chances that that's actually going to pass in the next session?
In the next session, I think that, we were just discussing this earlier about the incredible momentum this issue has seen this session, last session, more than ever before, and the coalition continues to grow and the organizations in support. And every day there is another article, another company that's coming forward supporting paid family leave. It's becoming widely understood that paid family leave can and should be available to workers in New York State. And I would add that we have an existing system in New York State that we could easily build upon here to make paid family leave a reality. So New York is well positioned to be the next state to provide paid family leave. So we are encouraged and hopeful, as we move into the next legislative session. And Corinne, I don't know if you wanted to add anything.
Yeah, I'll just add one thing. I mean, you might have seen, I think it was back in the early part of the year, Governor Cuomo was asked a question about family leave at a press conference, and I think he said something like, Albany doesn't have the appetite for paid family leave. And shortly thereafter, a group of a sign-on letter was circulated throughout the state, and it garnered a huge number of women leaders signing on and saying, no, in fact, we all have a huge appetite for paid family leave. And I think that really changed the dynamic up here. So I guess, for the person who asked the question about what are the chances next year, I think they get greater every year. I think that the level of dialogue around paid family leave and its importance is really at an all-time high right now. But it's not going to happen in New York unless people continue the pressure. And so advocates still have a huge job to do in maintaining that pressure on the governor's office to show that there's a tremendous appetite for paid family leave. So I just would encourage those of you who are interested in this issue to keep up the good work, and if you're not yet involved in the coalition's efforts, to join that.
Great. And then, Corinne, I guess this one I will send to you as well, that you mentioned in your presentation about reproductive health that advocates could help urge the governor to sign the special enrollment period bill for pregnancy. And what can we do as advocates to help support that effort?
Yeah. when it's unclear about where the governor's position is on a particular issue, and a bill has been passed by both chambers of the legislature, it's a good idea for advocates to send messages to the governor, letting him know how important the bill is. And so, this bill that would establish a special enrollment period for women who become pregnant to enroll in health insurance, both on the state health insurance market, but also for private plans. It would be great if folks were to send a message, and that could be done through social media. It can be done through a letter to the governor, sent by email or sent by hard mail. Providers who understand the importance of prenatal care could send in a letter encouraging him to sign it, because it will enable women to receive the critical prenatal care that they need. Women themselves who are uninsured could write in and talk about the importance of being able to enroll. So, voices are necessary on this one, I think. We're unsure where he stands on this, and any help that we can get in establishing how important it is would be helpful. My email address is at the end of this presentation, and if folks want to see sort of an example of a letter that you might be able to send, I can certainly work with you on that.
Great. Well, we're closing in on almost 3 o'clock, so
Okay.
unless there are any other last-minute questions, I guess, Dina, if you want to wrap it up, that'd be great.
So thank you, and thank you, everyone, all of you, for participating and learning about the advances, the many legislative proposals and bills that were advanced this session, and we're really excited about what's we've been able to accomplish together and what lies ahead in terms of our ongoing struggle for women's equality. Just wanted to flag our at A Better Balance, we do run a free hotline, so particularly around the workplace issues. If you do have questions as these laws are going into effect, or folks who feel their rights have been violated, you are welcome to call our hotline. And we will have, and Corinne's information and NYCLU's information is there as well. And then we will be sharing with folks these slides afterwards and other materials to reference for your own work, and as you to help you get the word out as well. And again, feel free to reach out to any of us with questions. And thank you again for participating, and have a wonderful afternoon. Thank you.